Thank you for having me. My name is Nicholas Stewart and I'm a partner at LGBT law firm Dowson Turco Lawyers. It's hard to pronounce. I'm also the Vice President of Australian Lawyers for Human Rights and I chair the LGBTQA+ subcommittee. Last year I was awarded the President's Medal from the Law Society of New South Wales. Sure. Last year I was awarded the President's Medal from the Law Society of New South Wales in relation to my campaign for 2 parliamentary inquiries and a judicial commission of inquiry into LGBT hate crimes in New South Wales. I was invited to come here because Keith Quayle, who was the initial speaker, is a client of mine in the Walluма Court of New South Wales. The Walluma Court, or the Walluma List, is the inaugural First Nations court for sentencing of First Nations offenders in New South Wales. It was launched in February last year and looks to bring offenders before not only a judge of the district court, but also elders within the within the First Nations community and sometimes within the LGBT community to factor in First Nations principles in sentencing. Keith's experience of that has been quite significant in terms of, and I'm not disclosing anything that he wouldn't have disclosed to you today, but being charged with a serious offence and then applying to the New South Wales District Court to be brought before a sentencing court that takes into account First Nations principles. It's a luck of the draw system. It is not just an ordinary process where you are eligible and will get into the list. But the benefit to him has been enormous. He's been granted bail, he's been able to be housed in rehabilitation centres, and as an LGBT First Nations person, he's had the benefit of myself as a member of the LGBT community advocating the intersectionality between being a member of the LGBT community and being a member of the First Nations community, which many of you would know is a complex intersectionality. Unfortunately, Keith is not here today, and I suspect that is because of the pressures that he faces as a person within the First Nations community. He experienced significant trauma as a child. He has experienced significant trauma in prison. He has experienced violence and persecution at the hands of police forces and agencies of government. And it's for that reason that we need a First Nations court like the Walluma List in New South Wales to be expanded, not only to our regional fringe communities in Sydney, but more to the regional communities of New South Wales and across Australia, because First Nations people are overrepresented in our prisons, as you would well know. So that gives you the context of why I'm here and talking about the experience of First Nations people in prison, but I also want to talk about the experience of First Nations people generally. One of my First Nations clients died 2 years ago after he was released from prison and placed in accommodation which was not appropriate for him by Community Corrections New South Wales. He was a known drug abuser, but was placed in accommodation where he was exposed to drug users and suppliers, which in turn led to him using and being in breach of his probation and overdosing and unfortunately dying. That incident itself was extremely awful for his family and for his legal team, but I think in some ways we've learned a lot from that experience because we successfully petitioned the New South Wales coroner to conduct an inquest into his death, even though it was not strictly a death in custody because he had been released on parole. We were able to use his disability as a leverage point to have the coroner investigate the circumstances of his death. That is not the ordinary course of things in New South Wales. The Coroner's Court is overloaded with cases. First Nations people, by virtue of their identity, do not always get access to the Coroner's Court. Often there are other factors to be taken into account, and I consider myself privileged to be able to help his family get truth and justice in the Coroner's Court. and I look forward to a hearing in September where we can really get to the bottom of the circumstances of his death and why more wasn't done in relation to caring for him. Now, I'm just going to tell you quickly a bit about the Walluма Court because it's really important that the wider community understands what it's about. So Walluma is a word from the Darug language and it means come back and return. In the context of the Walluma list in the District Court of New South Wales, it is a coming back of identity, it is community, it is culture, and it's healthy, crime-free life. The aims of the Walluma list are to reduce the risk factors related to reoffending by Aboriginal and Torres Strait Islander offenders, to reduce the rate of breaches of court orders by them, to increase compliance with court orders, to reduce the over-representation of Aboriginal and Torres Strait Islander people in custody, and to increase Aboriginal and Torres Strait Islander community participation and confidence in the criminal justice system, and finally to facilitate a better understanding of any underlying issues which may increase the likelihood of reoffending. I see the LGBT community's experience as parallel to First Nations in some ways. And the reason I say that is because having campaigned for judicial commissions of inquiry into LGBT murders, I've seen that by virtue of my own middle-class privilege, I've been able to speak for a wider community and to some extent obtain truth and justice. And that journey is continuing. But at the same time, many First Nations people have been murdered. Their deaths have been written off as suicides and there have not been inquiries of the same kind. So I give credit to every First Nations person in this room who's here to hear from people like me and other speakers. But I would also encourage you to reach out to me and see what we can do to increase the visibility of First Nations people in the criminal justice system, not just as offenders, but also as victims. Thank you.